No person may judge their own case. Nemo judex in party sua. Generally, the dead language is prohibited from use in our courts, but, arguably, there is a case for its inclusion in the national curriculum for our schools, especially when, judging from an employment tribunal case, the governors of a school argued unsuccessfully that it had delegated, lawfully, the powers of a staff disciplinary committee of at least, therefore, could have been more, 3 governing members, to its head teacher of 1, 2, investigate a case against a teacher, decide whether that teacher should be the subject of disciplinary measures, conduct the case against that teacher at the disciplinary hearing, sit in judgment, as the staff disciplinary committee, now, of course, of one that is the head teacher herself, at the same disciplinary hearing, make submissions, as the prosecutor, wearing her head teacher's hat, to herself, wearing her staff disciplinary committee hat, decide on the evidence put by both her and the teacher in question, decide whether or not she favored her own submissions, made to herself, over those made by the teacher against what she says, reach a decision based on the case put by herself, and, finally, decide on and impose the sanction. No guessing which way she would decide were a teacher to be so unfortunate as to have to face disciplinary proceedings commenced by her at her own instigation, following her own investigation. The facts of the case are interesting to say the very least. The claimant was employed by the school as a teacher. Part of the terms of his contract of employment stated, since September 2003 regulations made under the Education Act 2002 have given greater power to governing bodies to delegate their powers, including their power to dismiss staff, to head teachers if they so wish. Consequently, governing bodies must have regard in applying the disciplinary procedure to guidance issued by the Secretary of State in relation to these powers. Clause 8, 6. 2 of the school's disciplinary procedure stated, a final written warning may be imposed by the head teacher or staff disciplinary committee. If there is a possibility that the teacher may be dismissed, the matter must go to the staff disciplinary committee. Therefore, if a possible final written warning, and no worse that is dismissal, that sanction could be delegated to the head teacher to impose. However, in the event of a possible dismissal, such a matter must go to the staff disciplinary committee. This is clear. Under the head teacher's regime, in the space of just 15 months the claimant was the subject of 3 disciplinary proceedings. At the last of the trio of disciplinary hearings where the possible outcome could be his dismissal, the claimant stated that he expected the hearing panel to consist of 3 governors of the school and not the head teacher. He made reference to the terms of the disciplinary procedure. Surprisingly, despite having 2 advisors present to assist her, or, rather, in theory, the school, the head teacher was not, or it was not made known to the claimant, told by either that she could not be prosecutor, judge and jury in her own court, even without sight of the disciplinary procedure. The question of fairness, if only to be seen to be fair, ought to have raised some concern, amongst the advisors present, if not the head teacher herself, who, after all, were there to advise on the process and its fairness. It begs the question, if this process was deemed fair, then what would it have taken for them to have deemed it to be unfair? We shall never know. And surprisingly, each of the disciplinary hearings, during which he wore all 3 hats, the claimant's defense, was unsuccessful. Put simply, the head teacher upheld her own complaints on each and every occasion. The claimant complained that the head teacher's role at each stage of the disciplinary process was a breach of the school's disciplinary procedure and, if nothing else, unfair and or a breach of natural justice. He appealed her decision. For various reasons the appeal was heard in his absence and the head teacher's decision was upheld. In consequence, the claimant resigned and presented a complaint to the employment tribunal, alleging unfair constructive dismissal. At the hearing, the employment tribunal had to determine whether the school had been guilty of conduct that was a significant breach of the contract of employment, going to its root, or which shows that the school no longer intended to be bound by one or more of its essential terms. The claimant had left as a result and acted promptly, applying, amongst other things, the leading authorities of Western excavation D. Sharp and Malik v. the BCCI. The employment tribunal concluded that in the circumstances it had, no doubt, that the claimant had been constructively unfairly dismissed. The employment tribunal said, amongst other things, that in its view, there was no delegated power within the procedure itself. Clause 8, 6. 2 to which I have referred and on which the school relied so heavily was merely stating that in the event of the staff disciplinary committee coming to a determination that a member of staff had been guilty of, say, misconduct, the staff disciplinary committee could delegate the sanction less than dismissal to the head teacher rather than impose the sanction itself. Therefore, the head teacher in such circumstances had the power to impose a final written warning or less. The tribunal gained comfort for that interpretation by the fact that part of clause 8(6)(2) said, if there is a possibility that the teacher may be dismissed, the matter must go to the staff disciplinary committee. So, in other words, the staff disciplinary committee of governors was the only body that could decide on a case against a teacher where there was a possibility of a dismissal. In the ET's opinion, to attempt to incorporate the word head teacher into the procedure in place of the word staff disciplinary committee made no sense whatsoever. On any account, this case is extreme. However, it is still not uncommon to have a person in authority and, naturally, of influence to be involved in more than one stage of a disciplinary process where there are obvious alternatives. Dangerous. Admittedly, the opening phrase, "No person may judge their own case," does not fully cover the many breaches identified by the employment tribunal, but it was the closest one could find. I guess our friends from the classical world would have thought a phrase covering fully the head teacher's many acts of breaches and misfeasance would have been redundant and unnecessary. How wrong they were.